Right, morning, ladies and gentlemen. Okay, you must be wondering, why am I talking about LPA when the title of this seminar is Investing in Uncertain Times? Well, the whole idea is this, right? Once you've got some assets and you want to make sure that you're provided for, this is one of the tools you can do to protect your assets if you should lose mental capacity. All right, so let's just get started. Okay, the first couple of slides are about stats, about the social landscape in Singapore. I think about more than half of us here are over 50. So, I'm not saying that we're going to get dementia, but the studies show that this is something which is will be increasing in time to come. And expect that 1 in 10 Singaporeans aged 60 and above will have dementia in time to come. Okay, and when we talk about, of course, dementia is related to old age, but actually that's, getting an LPA doesn't mean you need to do it because you're getting old, because you can lose mental capacity at any time. It could be a result of an accident, not just illnesses. All right, and especially if you're young and this happens and you have a family to support, there could be quite disastrous consequences for the family. Okay, this is a recent commentary in the Straits Times. This was from the Young In case, and I mean everyone's familiar with that case, but I won't say too much about it because it's still on appeal. But the idea is really this document, if you have this document, because you choose the person who's going to be dealing with your assets, presumably you trust that person to do whatever is necessary to protect you and to do things in your best interests. So really, you should do it before you start showing signs that you are not going to be able to manage your own matters. Okay, the Mental Capacity Act was passed in Parliament in 2008, but only came into operation on 1st March 2010. Now, the whole purpose of this act is to enable adult Singaporeans to carry out pre-planning. Now, what is this document called an LPA? It's a legal document. Basically, what you do is you give authority and powers to a person whom you choose, whom you trust, to do things for you should you lose mental capacity and you can't decide for yourself. And this document must be registered with my office before it can be used. Okay, the MCA also contemplates this concept. All right, a person, the basic underlying idea is that you have respect for the dignity of the individual, right? But we also recognize that mental capacity can fluctuate. So if you have full mental capacity, there's full respect for autonomy. You decide what you want to do, which also means that if you make an unwise decision, really, that's your decision because you had full capacity to do so. And of course, unwise decision doesn't mean that you have lost capacity, all right? Then if you have partial mental capacity, then we respect the residual abilities. Whatever you have left, if you can decide, you will decide. If not, support will be given to you to help you make those decisions. And of course, the last category is you've totally lost it, then the law recognizes that you are vulnerable, and there are certain things which can be done to protect you from harm. And the person who eventually helps make that decision for you must do so in your best interest. Okay, so LPA, the next few slides I will go into some detail over these things, but generally this is what it is. Like I said earlier, the key thing is choice. You decide, not someone else, not the court. All right, and you decide what you want your donee to do. Now, if you make the LPA, you are known as the donor. The person you give the powers to is known as the donee. And the powers which, and the areas where they can help you with are two: personal welfare or property and affairs. Okay, what do I mean by personal welfare? So, for example, the donee can decide where you should live, who you should live with, the day-to-day care, whether you should take part in certain social activities, and medical care. Some of these decisions also cover deciding, whether you should be residing in a nursing home and making arrangements as such. Property and affairs are basically financial in nature, so opening, closing bank accounts, managing CPF accounts. If you're an investor, then receiving dividends income on your behalf, and also dealing with property, buying and selling of property, rental and mortgage. Okay, so even if you were to make an LPA and you give all those powers to your donee, the Act itself has got inherent safeguards. And no matter what, all these decisions cannot be done by your donee. So, for example, the donee cannot consent to marriage. They cannot consent to touching of a sexual nature, cannot consent to divorce, adoption of a child, change of religion, change of gender. HOTA is Human Organ Transplant Act, so donation of your organs. Cannot make or revoke your advance medical directive if you've got one. Cannot consent to you being used for medical research. Cannot agree to voluntary sterilization nor abortion. But of course, some of these things, like a divorce, for example, you can always go to the court to ask for specific power to act on your behalf for divorce matters. Okay, there are also some other statutory safeguards under the MCA. So if it's a company who's been appointed a donee, obviously if the company has been wound up, cannot act as a donee anymore. Death, that's pretty obvious. Bankruptcy for financial matters. And of course, if your donee himself has lost capacity, and if you have appointed your wife as your donee, if unfortunately you go through a divorce, that appointment also lapses. Okay, after all that, why even bother making an LPA? All right. To me, the first point is the most important. You have the choice of who you want to act for you. Now, if you do not have an LPA, it's not that nothing can be done after you've lost capacity. You can always go to the court to ask the court to appoint someone. Not you. I mean, the person can go to the court to ask the court to appoint him or her as your deputy. But by that time, you have lost capacity. You did not choose that person. So it's usually a family member. And, if everything is fine at home, your kids, family members are united, it's fine. But sometimes, there's family disputes. And that gives rise to a lot of conflict when they come to court. And because it is your choice of who you want to act, you can also decide how much or how little you want that person to do for you. If you go to the court, it's actually that person who's applying who will tell the court, give me all these powers. Not exactly what you want, because you're not in a position to say so. Right? And of course, if you go to court, that will take time, much longer than having an LPA, because an LPA is activated when you lose capacity. I suppose the only time lag is when you go and see the doctor to get the medical report. But apart from that, it's actually pretty fast. Going to court takes about 3 to 6 months before the court order can be obtained. If there is a fight within the family, it can go up to 18 months or longer. And going to court means you probably have to engage counsel, lawyers, and that's, again, another sum of money. So how do I make an LPA? before you decide to do this, first thing is decide on who you want to appoint. The usual persons we see are spouses, children, parents, relatives, close friends, associates. But the key thing is choose someone whom you trust. All right, someone who you've known a long time, someone who knows your values, someone who knows what you like or dislike. Because then you can be sure that when you lose capacity, they will be doing things which you would have done had you been fully capable. All right, and obviously, if you have a large estate, you may want a professional to deal with your monies, perhaps a trustee, trust companies, all right, but someone who has the required expertise in the area. And of course, they must be above 21 years of age. Then after you've decided who it is you want to be your donee, you decide what it is you want this person to do. Now, there are two types of forms which you can use. There's a LPA Form 1 and LPA Form 2. Form 1 basically says that it's general power. Everything, no limit for the donee to do. So very general powers versus specific powers. But even within that, you can also decide that this donee can only make decisions on your behalf for personal welfare matters and property and affairs, or both, or maybe just one of the above, right? You can specify. And if you can appoint more than one donee, 2 if you use Form 1, but if you appoint 2, more than one donee, you have to decide whether you want them to act jointly or jointly and severally. What does that mean? Jointly means both of them must agree on the decision. Severally means one of them can decide on your behalf, all right? And sometimes it's usually good to appoint a replacement donee as well, just in case the one whom you initially chose cannot act. So if there are more than 2 donees, you want to appoint more than 2, and more than 2 replacement donees, and you have very specific powers which you want to give to the donee, then you have to use Form 2. And this has to be drafted by a lawyer and lodged with our office. So in terms of LPA Form 1, the registration fee has been waived up till September 2018. Form 2, I think there are fees payable for Form 2. It's $200 for Singaporeans and $250 for Singapore PRs and $300 for foreigners. Right, so after you filled up the LPA, you have to see this person called a certificate issuer. Now, this person is either a practicing lawyer, a psychiatrist, or an accredited medical practitioner. The OPG website has a list of these people, so you can go check. Accredited means they actually go through some sort of a training course with us, and then they're accredited and be able to do so. Just a note, you actually have to pay the certificate issuer for certifying that you have the mental capacity to make the LPA. Their fees vary, so please check. You can just call them up one by one and decide who you want to use. Okay, so in a nutshell, this is the process. Pretty straightforward, I think. And just another thing as well, we actually rolled out an electronic system at the beginning of this year. It's actually an electronic LPA form maker. So if you don't want to do hard copy, because I believe there's some stuff in the bags which was given out to you, some forms, you can actually go online and that helps you, it guides you to filling up the form. But unfortunately, you still have to download it and print it and bring it to the cert issuer for signature, because currently the law requires that a hard copy signature be obtained. But I think that will change in time to come. Okay. So the MCA was actually passed about 6 years ago. So early this year, in March, it was amended. Because after it run its course, we realized that there are some things in there which needs to be enhanced to further protect the vulnerable person. So one of the key trends which came out, as ministers said in Parliament, was that there's a rising number of singles and elderly persons, as well as those who are married with no children as well. And we really need that to strengthen the protection capability of the Act. So these were the key amendments. I'll touch on only some of them, but there's this concept of a professional donee and a professional deputy which was introduced. There were provisions for better protection from abuse by donees and deputies, provided more commercial certainty for the use of LPAs, and gave my office some powers to do more things. Okay, so what's this professional donee deputy thing? Now, by the way, this hasn't come into operation yet, although the Act was passed in March this year. So that's because my office is in the process of setting up the framework for this, because we have to register a professional donee or a deputy, as well as to train them before they can act as such. The difference, the professional donee is entitled to charge for his or her services, which is why it's imperative that they know what they're doing. Currently, if people want to be paid for acting as a deputy, the court has to sanction it and allow it to be deducted from peace monies. And in the course of developing the framework, we have been, in the past couple of months, been engaging with our stakeholders to make sure that things will work on the ground. Right, and I think one of the ideas we have as well for the professional deputies is that we want them to be registered professionals in their own fields as well. So, for example, you're looking at lawyers, accountants, doctors, healthcare workers, social workers, right? So that there is an independent body also having oversight over what they do. So if they, do something naughty, they can be reported back to their organizations for disciplinary proceedings. Of course, the other ideas we have also relate to training. So we recognize that, just because I'm a lawyer doesn't mean I'm any good at money, or numbers. I think, so we probably will need training in accounting, how to do basic accounting perhaps even, and obviously a social worker perhaps may not be so familiar with the law, so they have to be trained in these areas. Then of course there's another big, I alluded to trust companies earlier, so this is going to be one group which will be exempted from these requirements, and they can act as professional donee as long as they are registered as a trust company with MAS. And once they are registered as donee or deputy, they can offer their services. But that doesn't mean they start acting straight away. The court has to appoint the deputy, and obviously the donee has got to be appointed by the donor. Okay, better protection. This simply, okay, currently there are certain grounds for the court to revoke a deputyship order or to revoke the LPA, but this is new. If that person has been convicted of an offense which smacks of dishonesty or fraud, and even if this offense was committed against a third party, not necessarily the donor or P, this could give rise to a situation where the court say, look, it's not appropriate for you to act, and someone can apply, including my office, right, to revoke the LPA or to suspend the deputyship order. And this can be done even though investigations are still in progress, so that the power is taken away immediately, and then the chap doesn't go on and further dissipate the assets. Okay, and of course, another key feature of the MCA is this whistleblower feature. So if you know of anyone whom you suspect is being abused, a vulnerable person being abused, neglected or ill-treated, please, you can report this to my office. My only request is if you could give us, get some detail. Don't just say, oh, I think this happened, but some details like, who, where, how, when, that sort of thing. And then we will start the ball rolling and get the witnesses to come in and get their statements. If there is a case, a few things we could do. Serious enough, it goes to the police. If there is a LPA, we could start the process of revoking the LPA. If there's a deputyship order, we will start the process of revoking the deputyship order as well. And whistleblowing is not just from your own family members. I mean, if you, friends, relatives, neighbors, this also happens because, I mean, if I want to use the case of Yang Ying, for example, the whistleblower in that case was not a family member, but a neighbor, was a good friend of the lady, right? And if you need more information, the website is there. We've got Jamie. Jamie is an automated system. She's been given a set of the usual questions, so that's instant answers if you need. All right. Thank you very much.